18 with the state.
Thank you, Judge. All right, page 18, at the top we have conjunctive, disjunctive, which actually is the pattern 1.4015. And the state just requested that it be specially tailored, and the court is correct. It is both count 7 and count 9, where we have an and, which of course in legal terms for demurs means it's an or. So what we have is on count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck or a Chevy Silverado pickup truck, an object, etc. And then we have count 9, which of course is in violation of the personal liberty of Ahmaud Arbery, did unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks, and did attempt to confine and detain him without legal authority on Burford. And that is under criminal attempt to commit a felony. So we asked for the conjunctive, disjunctive on both counts 7 and count 9. And then we have the affirmative defense, of course, justification, and then the statute 17460, grounds for arrest, citizen's arrest. Now, when we get to the bottom of page 18, we have right and duty to execute a citizen's arrest. The state objects to this particular charge. This particular charge provided by the McMichael defendants cited to Long versus the state.
Hold on a second, let me get there.
Sure.
Sorry, grab my own. Hold on. Which number was it?
This is their request to charge number 3.
Got it. Okay, go ahead.
All right, so what we have here is we have something that says it is not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed, any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. That is what they have requested. The problem is, Judge, they have based it on a case that doesn't apply to the facts as we have them here, and that is Long versus the state, 12 Georgia 293. It's from 1852, so Civil War was over 1865. Women got the vote in 1919. So this was in 1852. The thing about this case that's really interesting is that it's kind of the first bribery extortion case. So what we've got is we got a guy, and he's in a wagon, and he's got wagon wheels behind him, and he's going down the road, and these guys jump out, and they go, "Aha, you have the stolen wagon wheels." And he goes, "You know, I didn't steal these wagon wheels." They're like, "Yes, you stole the wagon wheels. We're going to take you to jail. We're going to take you to jail." And he's like, "No, go talk to this other dude. He knows that I didn't steal these wagon wheels." And they kept going, "We're going to take you to jail. We're going to take you to jail." So after this goes on for some time, they said, "Except if you wanted to pay us off, maybe, we won't take you to jail." So they go to his house. He goes ahead and pays them off. If the court looks closely at the case, you'll find exactly how he paid them off, which is highly unusual, and I won't mention it here, but it's distasteful. And he pays them off. So they go ahead and they go off, and they tell him, "You got to get out of town now." Instead, he goes to the sheriff, and he goes, "Hey, sheriff, these guys just robbed me by intimidation because they said they were going to throw me in jail, and they were going to arrest me, and they were going to do all these things because I committed this crime of having stolen wagon wheels," which I didn't. But instead, they said, "Well, pay us off, and we'll go away. You just have to get out of town." So the men who are actually on trial in Long, the guy Long, he's actually one of the men who was extorting money from the victim. And what the court said was, "Hey, if you're going to go ahead and do a citizen's arrest, Defendant Long, it's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, not extort the felon." I mean, if you really think they're a felon, you can't go ahead and extort them by going, "Well, if you don't want us to take you to jail, why don't you pay us off?" And what the court held there is that that is intimidation, and it's illegal, and they were convicted. Now, the Long case is cited in 81 cases here in Georgia, but it's always cited for the proposition of intimidation. It's kind of the statement of this is what intimidation is, all the way back to 1852, where you cannot basically act in the capacity of a citizen's arrest. I mean, here we are in the middle of Georgia. There is no police force. It's 1852. We're talking wagon wheels. We're talking a guy riding horses with a wagon. So at this point, the court's going, if you're going to arrest somebody, you arrest them. And that's where this dicta comes from. It's not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon. It has nothing to do with, hey, regular citizen, you are at the Shell gas station, and there you are, and you witness a carjacking. You have a duty to go over and arrest the carjacker. Okay? We all know that there's numerous carjackings, murders, everything else that happens in front of a whole bunch of people, and those people all run away. They don't bother to arrest the gun-toting armed robber or the gun-toting carjacker. So this is not actually what the state of the law is. There is no affirmative duty on a citizen who witnesses any sort of crime, a murder, a rape, an armed robbery, an aggravated assault, to affirmatively go and arrest that person. None whatsoever. So, number one, there is no affirmative duty on a private citizen when a felony is committed to apprehend the felon. That is not the state of the law right now. In addition, this is based on a case from 1852 that was saying, once again, hey, if you're going to act as law enforcement, if you're going to go ahead and make an arrest, make the arrest. You don't get to extort money from the person you're threatening to arrest. Now, this defense is probably going to come up here and go, well, it was cited in Johnson versus Jackson in 1976. And it was. But that case actually was a law enforcement officer who's pulling up in his driveway. And there's a strange car there, and there's two strange guys, and they're coming from his garage. Turns out they're brothers. So he gets out of his car, it's dark out. He's like, hey, what are you guys doing? What's going on here? In traditional fashion, they both answer at the same time with completely different answers. So he's very suspicious because, hey, they've come in from his garage. He doesn't know them. They're here. He doesn't know what's going on. They immediately bolt and try and run him over with their car. So they go and they run him over, or try to run him over with the car. He, of course, home from work, he's a law enforcement officer, pulls out his gun and goes ahead and starts shooting at him. What happens? He shoots one of them in the back of the head through the rear of the car. This particular case is actually a civil case, all right? At issue here is the relation between landowner and burglar or felon, the owner's right and authority to arrest the felon, and the allowable force and effectuation thereof, and the duty owed by a landowner to one who is there for the purpose of committing a felony, all of which is for the determination of the jury. But once again, remember, this is a civil case. This is a man who is at his own personal property and sees them going into the garage and starts questioning them. They then try and run him over with the car, and then he shoots and kills one of them. He was sued by the parents of the young man who was shot in the back of the head, fleeing. So, while trying to identify the two strange men unlawfully on his property, Jackson was violently assaulted when Johnson swerved his automobile to strike him, causing Jackson to fear for his life and also making it impossible for him to read or take down the license tag number of Johnson's car, of course, as he went away. So this is the most recent case that actually is sort of on point. And they go ahead and they then cite to, I'll find exactly where they cite to it. They cite to Long over here about it is not only the right but the duty of a private citizen when a felony is committed to apprehend the felon. And they go on to cite that. In addition, they then cite to another 1890 case and then a 1926 case that a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while doing so is equally under the protection of the law. So that case really is not similar to this case at all. I think that this is a misstatement of the law as it applies to the facts of this case, and the support for it, these two cases that they cite, one of being a civil case from 1976 with the U.S. Marshal in his driveway, really doesn't have the same facts that we've got where it's a duty of a private citizen. So my fear, of course, is that charging them on this law, the defense is going to get up here and go, well, he had no choice, he had to do it, it's his duty to do it. It's not only the right, but the duty of a private citizen, making it seem as if there's consequences to him if he doesn't do it. There are no consequences to him if he stands in his driveway and does absolutely nothing. But this charge actually makes it seem, and they're probably going to argue, that there was some sort of duty, therefore some sort of consequence to him, which is not the law. We ask that this charge not be given.
All right, that was a McMichael's request.
Allow me to retort. If I may say, speak from a seated position, I have notes and computer and all that. Well, the Long case is, in fact, the first case in Georgia's history that cites the citizen's arrest statute. And it cites it in the exact same wording that it existed in our state up until 2020, when it was modified and changed very much. The fact that it's an 1852 case shouldn't count against it. I think count one is murder, which goes back to the code of Hammurabi about 3,500 years ago. So the age of a law makes no difference to it. And I find it of interest and like to add this for the court in considering this statute, that the Georgia Supreme Court didn't come into existence until 1846. So we were only 6 years into the existence of the Supreme Court when Long was decided. And Long was, in fact, a citizen's arrest case. That's the defense that was raised. And it was very well analyzed in that old case. And I also would like to point out, too, for the court, that many people confuse the citizen's arrest law by calling it a Civil War era statute, or sometimes we've heard it referred to as a slave catching statute, both of which are false. The reason it's called Civil War era statute is because Georgia codified its code in 1863, as we all know. That was the first code of Georgia. And the statute that the code included on citizen's arrest in 1863 had been in existence since the year 1215 in the statutes of Winchester in England. It was then English common law, was brought to the colonies. It existed in its present form in the colony of Georgia, and then when we became a state, it was in our laws, as all of our laws were then, scattered in pamphlets and cases and statutes, until we got it all collected, the first state in the nation to collect all their laws in one place and call them the official code of Georgia. And that was 1863. Now, jumping forward then to 1976, the case Ms. Dunikowski just mentioned, which is Johnson v. Jackson, 230 Southeast 2nd, 756, or 140 Georgia Appeals 252. It's a 1976 case. I'd like to read a paragraph from it. It cites the statute as it existed in 1976 in the exact same words it existed in 1852, as well as it existed in 1730 when Georgia became a colony, and 1787 when we became a state. Same wording. And then that case, Johnson v. Jackson, goes on to say this: it is not only the right, but the duty of a private citizen when a felony is committed to apprehend the felon, and after a felony is committed. Any private person may arrest the felon with the same view upon reasonable and probable ground of suspicion of his guilt. This 1976 case is citing Long v. State from 1852. Then it goes on to cite, a private man has quite as much power to arrest a fugitive felon where the emergency calls for immediate action as a public officer, and while so doing is equally under the protection of the law, citing Croom v. State, an 1890 case. And then it goes on, and he apparently has the right under to arrest under certain circumstances in order to prevent a felony from being committed, which felony has not yet been attempted, citing a 1959 case. And after citing those cases without overruling any of them, of course, this is the Court of Appeals, but it didn't go up to the Supreme Court. None of those rules have been overruled. They go on to say of Jackson in this case from 1976, this is the U.S. Marshal who was off duty, came home, found the two brothers sitting in an idling car in his driveway with his garage door partly open. Based on those circumstances, he wondered, what are these two guys up to? So we inquired of them, why are you sitting in my driveway in an idling car and I can see my garage door open? And that's when, after one of them gave him his wallet, they drove off and he fired 2 shots at them and killed one of them. And so this was a civil case for wrongful death. And the court says Jackson, the off-duty U.S. Marshal, attempted to make a citizen's arrest. And this is right after what I just read, the paragraph I just read. Based upon what he saw prior to the assault and flight of the deceased, which resulted in the fatal shooting. What are reasonable and probable grounds for suspicion is for the determination of the jury, as is whether the circumstantial evidence was sufficient to establish the commission of a burglary. That's the crime he suspected, was burglary. The questions of whether the force used was reasonable or whether the killing was under the circumstances necessary, because he raised a self-defense claim, because the car hit him and knocked him over. The analysis is very similar to here. It converted from an attempted citizen's arrest into self-defense when the car nearly ran him over. And so they were saying under either situation, those circumstances likewise are to be submitted to the jury. So while they're, long as an old case with a very convoluted and fascinating story behind it and an interesting history, it's still being cited all the way up into the 1970s and beyond. And it's never been overruled. And it basically just states what ultimately became the code of Georgia anyway, and the statute that we're operating under. But the language that we've taken from the case is still good law, and we defend it and ask that the court give it to this jury.